The broadcast is now starting. All attendees are in listen-only mode.
Hi, this is Alan Gassman, and it is 5 p.m. on Tuesday, June 20. And where would you rather be than here in a little clinic on learning to draft power of attorney documents? But the good news is that if you're attending this tonight, you are going to get a Word or WordPerfect, or both if you like, version of our power of attorney form, which you are welcome and invited to improve on. You just have to tell us what the improvements are. Now, the vast majority of the attendees here today are members of the Clearwater Bar, and we welcome you and thank you for all of your support over the years, or at least all of your tolerance over the years, as we've developed our practice and our forms. All right, page 2 of the PDF, of the handout, which you should be receiving separately from us, or you can view it on file. I want to mention that we thank B&A for allowing us to use their form from portfolio number 859, and what you are seeing today will be added to the B&A portfolio in a special small section on the Florida law, and then also a Florida power of attorney form, because if you use a normal, general, nationally recognized power of attorney form, it's not going to work. Also, we thank Jay Fleece and Hamden Baskin for their recent thoughts on potential traps under the new statute. One of the other enclosures that you're going to receive by email is our multiple-page outline on this new law. It is quite interesting, and it is quite complicated. Page 3, we thank Judge St. Arnold for his comments in the last webinar we gave on this, which you can view at our website, or if you have any problem finding it on our website, you can just call our office or send us an email, and we'll be glad to help you with that. Page 4, we thank Karen France of the Clearwater Bar for all the help she gives us. We donated 35 copies of our estate planning book written for B&A this year to the Clearwater Bar, and if you buy this from the Clearwater Bar, all the money goes to the Clearwater Bar. We donated 35, so I think B&A probably has about 4,965 of them left if you want to buy it from B&A. All right, now, on page 5, I have the main catastrophes that can happen if you don't have a proper new power of attorney. This is what we want to keep our eye on, because we want our power of attorney form to cover all of these things to avoid these catastrophes. And the first one is, if you sign a springing power of attorney after September 30, 2011 under Florida law, it will be the equivalent of no power of attorney. So if you have a client who wants to sign a power of attorney that says, I appoint John Smith to be my agent, but only in the event of my capacity, they better sign that before October 1st. They need to sign it on or before September 30. Now, you can have an escrowed power of attorney, and we'll be talking about that in the form area. Second is authorizing an agent to conduct certain actions without separately signing or initialing each provision. That's really crucial. If you have a provision in the document that allows the agent to create a new living trust, that will not be effective unless it's specifically signed or initialed by the client. Also, the power to amend, revoke, or terminate a trust, the power to make a gift, which Chris is going to talk about later, the power to create or change rights of survivorship, the power to create or change a beneficiary designation, the power to waive certain rights under a pension or retirement account, and the power to disclaim property or powers of appointment. So that's 1, 2, 3, 4, 5, 6, 7 different times that the client is going to have to initial this document at minimum for you to give them all the powers authorized under the Florida law. Now, the next catastrophe, which we don't have on the PowerPoint for some reason, we'll add it next time, is you cannot just give a general power. You can't just say, I hereby give a power of attorney to my son Melvin to do anything that I could do under the law of the state of Florida, as if I were doing it. That will have no effect whatsoever if you sign that after September 30. You must give all the specific powers, and that's why it's so important that you have as many specific powers as you can dream of, and that's what we have for you today here. Next catastrophe, executing a power of attorney after September 30, 2011 without having 2 witnesses and a notary. to the signature. That's very important. A lot of laymen aren't going to realize that. I think most of the lawyers already do that. Also, just remember, healthcare powers of attorney require that the two witnesses not be related to the person giving the power. So you may want to follow the same procedure with your financial power of attorney, your durable power of attorney, but that's not necessarily required under the statute. Next, an agent is not eligible for compensation unless they are a Florida licensed lawyer, a Florida licensed CPA, a licensed trust company, or an individual who has never been an agent for more than 3 principals at the same time. So if you have a client who are using a professional guardian type of operation to do their work for them, you need to point out that that may not be a legal arrangement anymore. It may not be acceptable for the agent to do it for free, so that's something to be considering. Finally, there's going to be a lot of theft. There always has been a lot of theft. Theft is probably the oldest profession, so we have to be careful who we let clients give powers of attorney to and make sure people know whether we're representing the principal or the agent when we give a power of attorney. That's just one of the challenges of the law practice. Now, a little checklist for you on page 6. Number 1, you identify the principal. That's the person who gives the power of attorney. Secondly, you identify who the agent is going to be and who the alternate agents are going to be. You talk about how you're going to select the agents. You talk about whether the agent will be compensated. You talk about any special limitations on the agent, which we'll talk about under the document. Next, is the power of attorney going to be immediate or escrowed? Then the enumeration of specific powers required under the statute. We're all going to have forms that do that. Then the enumeration of the powers that require a separate signature or initialing. And, as I'm going to discuss, your own pet peeves, your own things that maybe the statute doesn't require signature or initialing, but you think it's pretty darn important to have it signed and initialed. Then discussion of gifting powers, which Chris will get into towards the end. G, whether you want the agent to have estate planning change powers, which I don't really like very much. H, exoneration of the agent from liabilities, which we're going to give you some language for. I, do you want to talk about investment parameters? Do you want to talk about what the agent can do with investments? And J, how it relates to the revocable trust and will language. By the way, I forgot to mention, but you probably know that at 5:30, our partner Ken Crotty is going to give a separate presentation for those of you who are interested in the common mistakes made with respect to the filing of gift tax returns and how to avoid them. He's got a Form 709 for you with completed pages. I think you'll find it to be very interesting. All right, now I'm going to go to our post-September 30, 2011 Durable Power of Attorney form. And again, I thank B&A for letting us adapt their form. B&A has granted you permission to use this form. And I thank my partner, Kenneth Stanley, who I see is on here today, for helping me develop what became the initial part of this form. Okay, I have the client's name here on page 7, John Client. He's appointing his spouse, Angie Client, as attorney in fact and agent. Now, under the new statute, please recognize that if either of them files a divorce petition or files a court separation petition, then the power of attorney has no force or effect. Now, here's an optional clause for you. Do you want to say that this power of attorney revokes any and all prior powers of attorney? I typically don't. I typically feel like an old power of attorney is better than no power of attorney at all. But one thing to check is, does the old power of attorney appoint people who the client no longer trusts? Okay, now Section 1, Kenneth, you may remember this language, a general grant of power, a power to appoint to do anything that I have the power to do. And this sounds good, but under the new statute is not going to do us any good, because the new statute says you have to have specific powers in the documents. So here's the language we've typically used. We've got a section on powers of collection and payment. We have a power to acquire, sell, or transfer. We have management powers. We have motor vehicle powers. We have interest powers. We have tax powers. And I've kept this all in. I haven't merged it with the B&A language because I just haven't gotten used to it all yet. I've got safe deposit box powers, and then here's something that a lot of you don't have. I typically do. I actually give my financial power of attorney the power to make medical decisions. Two reasons. One, if they show up at the hospital at 3 in the morning with the wrong document, they ought to be able to make the medical decisions. I don't have many clients who would not trust their financial agent with making medical decisions as a backup. So I've got that in my document. Secondly, there are financial medical decisions that may need to be made, and I want my financial agent to have full participation in my health care situations, including the ability to get my health care information so they know whether to pay a bill or what to do. Okay, now here's the part you've been waiting for, the special powers. These are the powers that you have to specifically have the client initial or sign in order to be effective. I'm on page 10 here. Now, one thing I have on page 10 is, do you want all these powers to apply to the successor agent or just the initial agent? So I have said they are I'm including giving these powers to my successor agents. Now, I actually thought of having the client initial one place if there was just for the main agent, one just for the successor agent, but my staff saved me from that complexity. We just decided that it's going to automatically apply to the successor agent. So the first item under the statute is banking powers. We want the client to specifically provide for the banking powers. The banking industry wants that. Secondly, to create a trust on my behalf. If there's a situation where I have assets in my name and they're better off held in a trust, maybe because I want to have a trustee who's allowed to be paid to administer those assets, then my agent should be able to create a new trust. We have a lot of language for that towards page 10, and you sign up on the top of page 11, and that could include a pooled trust to do some Medicaid planning. Then gifting. Now, we have all the language for gifting that we could imagine on pages 11 and 12, including language derived from the B&A portfolio on this subject. Chris is going to talk more about whether you want to be selective with your gifting, but I'll tell you most of the time my clients are appointing people they trust, and the ability to make a gift to the agent and themselves when it's a spouse or a children can be essential. This is certainly something to discuss with our clients, but I don't want to, because I'm on the soapbox here, set standards of practice that are any higher than are realistic. I don't think a client wants to pay me $2,500 to explain every aspect of this power of attorney to them. But you have to use your own judgment when you draft this power of attorney as to how much gifting ability you want the agent to have, or whether you might appoint a special gifting co-agent, which you might see someday in our next webinar, which would be I only allow gifts to or for the indirect benefit of my agent with the written consent of one of the following people who I hereby call my gifting co-agents. Okay, the sky's the limit here on different ideas. Top of page 13, number 4, converting or getting involved with a custodian, pay on death, or other type of investment or money holding account or arrangement. In other words, you've got an account that now would pay to Cousin Floyd on death. Maybe Cousin Floyd's drinking a little bit too much, doesn't need this, so we eliminate the pay on death account, put it into the principal's individual name or a revocable trust, and Cousin Floyd's a little bit upset later. Okay, number 5, we added this. It is not in the statute, but representation as to receivership, bankruptcy. One of our law clerks thought this was needed. I don't know if it's needed or not, but that's part of the consequence of using law clerks. Number 6, executing on my behalf instruments that are requisite or expedient pertaining to my property or to me. We thought that that was good for the client to initial, although it's not required by the statute. Number 7, statutory elections and disclaimers. Disclaimers are required by the statute. If you want the agent to be able to make a disclaimer, which I strongly encourage, then you want to have this provision or a similar provision in your document. And 8, working with retirement plans, waiving retirement benefits, anything having to do with the retirement plan. There's your separate signature. Number 9, this is not in the statute, but something that probably someday you'll see ethical opinions on. does your principal explicitly waive conflicts of interest between the agent and the principal? If I am Mary's lawyer and I am John's lawyer and they're married and John gives Mary a power of attorney, did I have a conflict of interest? And then one of them becomes incapacitated and the other of them does something to the advantage of the agent but not to the advantage of the principal. Is this something where the client should waive the conflict of interest? I hope that this would never be required and never be needed, but like they say about chicken soup, it can't hurt. Okay, then creation and change of ownership and survivorship rights relating to any interest in property. This may be an overkill, but we like to have it in there. Next, number 11, this is not required by the statute either, but I like to have it in there, the ability to loan money to the agent or a relationship of the agent, especially if this is a power of attorney given to a friend or a neighbor or even a professional who the client doesn't know well. Neither a borrower or a lender be, but these things do happen. So I would want the client to sign off on it or specifically exclude giving the agent the power to lend. So those are probably the most important items. Then section 10 below, we're going to talk about waiving certain agent duties, but we will get to that in due course. Okay, K and L, M, N, O, and P, just some other general duties that we've normally used. And now, the language provided by the B and A. Under P, I say to perform powers that are listed below with any duplication of powers being construed to most fully expand and not limit the authorizations herein provided. I liked my introductory language. I liked my general language. I did not want to merge it into the B and A language. But now in smaller print, and our form uses smaller print than you see here to take up fewer pages, I have the extensive B&A powers. And I'm not going to read them to you or we wouldn't be done in the next hour versus 12 minutes. But as you can see, there are many pages of powers. You know, I remember my third grade teacher said a preposition is anything a squirrel can do to a tree. So these powers are anything an agent can do for a principal. And I'm sure you're going to think of more things, but it's good to think of more things than to think of morphine. All right, now, Section 2, Interpretation and Governing Law, simply referring to the statute, telling everyone what this document is. Number 3, third-party reliance. We always like to have a separate provision that we can tell third parties, look, you're able to rely on this. Number 4, potentially important, photocopies. We typically say a photocopy is the equivalent of an original. And then everybody can lose the original as long as we have a scanned photocopy. But if you have a client who does not want this power of attorney to be active unless they're incapacitated or unless somebody else decides or corroborates their unavailability or their desire for this power, then you want our alternate form on page 28. So instead of number 4 here, which says photocopies, we go to page 28, and it says original required. It says photocopies or electronically transmitted copies hereof are explicitly not considered to be equivalent to an originally signed power of attorney. And an originally signed, witnessed, and notarized copy of this power of attorney will be necessary for my agent to act. And then I have a provision number 5, safekeeping of original. I have given the original of this power of attorney to the law offices of Gassman Law Associates, PA, and any attorney at that office has the discretion to turn this over to anyone. Now, we also have a separate escrow agreement that we have the client sign, which, believe it or not, indemnifies us and holds harmless for any liability or obligation that we might incur for trying to help them out and holding the original here. And if you'd like to see our escrow agreement, you just send us an email and we will be glad to send it to you. Number 6, disability of principal. It's my intent in executing this that this power of attorney will not be affected by my disability. Then 7, substitute agent. Now it comes to mind under number 7, I could have added a provision that said, notwithstanding any provision above, as to my substitute agent, the following will apply. Number 1, count the silverware before you give this agent my power of attorney. Number 2, don't allow the agent to loan money. Number 3, I've even seen this. I appoint John Smith to be my agent for the sole purpose of transferring assets to me into my revocable trust, so that if something happens where there's an asset and my trustee of my revocable trust needs it transferred to them, that's it. So you can be very creative with the limitations or requirements of a substitute agent. You can even name multiple agents and require joint signature. Under this new statute, if you don't require joint signature and you name multiple agents, it is presumed that each has the power to act with joinder or consent, without the joinder or consent of the other. Okay, then number 10, on page 29, number 10, waiver of duties. This language here is the fullest waiver of duties that you can give under the Florida statute. You don't need to separately sign or initial this, but I certainly would. You can sign away the duty to act loyally for the benefit of the agent. If I give a power of attorney to my wife and I become incapacitated, I expect that she can leave me homeless, take all these assets, and move into a mansion if that's what it takes to protect these assets for her. If that's the way your client feels about it, then you want this clause. No duty to not create a conflict, no duty to act with care, competence, or diligence, no duty to cooperate with people making healthcare decisions. I trust this agent. If you give somebody authority, if you give somebody responsibility, you have to give them authority. If this is the way your client feels about it, if this is the way you feel about it, that's fine. Here's the language for you. But client should sign this, in my opinion. Also, I have a provision here, an optional provision. If the agent is not related to me, then the above immunities will not apply. But still, they will be indemnified and held harmless for liabilities or obligations occurred in the absence of gross negligence or willful misconduct. You know, if you do anything semi-wrong, that the plaintiff's lawyer is going to come after you for gross negligence. So if you trust the agent and you want to give them the responsibility, I think you need to give them reasonable immunity if you want them to serve. Or you appoint a trust company, and I don't know what kind of immunity they're going to require. They have lots of insurance, and they're going to charge a lot of money and be very, very careful when they serve. Okay, Section 11, reimbursement and liability of agent. My favorite business law professor used to always say, number 1, get paid. How are you going to get paid? So talk about reimbursement and paying the agent. Again, I also have indemnification and hold harmless language here. I plan to keep it underlined in the form so that the client had a chance of seeing it. Next, this is something that B&A uses. It's not brought up in the Florida statute, but it's something to talk to clients about. Do you want the agent to have a responsibility or an obligation relating to the investments of this client? Do I want to become incapacitated and wake up in a year and find out that my CDs were put into the stock market because the agent I appointed conferred with a lawyer and was advised that under something called the Prudent investor rule, investments should be balanced? I don't know about you, but right now I have a lot of elderly clients who strongly prefer that their investments not be balanced under what we've always known as the Prudent investor rule. So I have just, for no reason whatsoever, come up with 180 days, that at least for 180 days there would be no obligation to rebalance investments. All right, that's the power of attorney form. The last page, page 31, I have the 2 signatures. I have a reminder that if I don't sign and initial certain of these items, I know they won't be effective. I do that because I know eventually some client's going to sign a draft that I send them. They're going to send it back, witnessed and notarized. I'm going to be on vacation. They're going to become incapacitated before we can say, hey, you forgot to witness or sign these. Did you mean to? So at least there, I've tried to remind them that if they don't witness and sign the provisions set forth above that require witnessing and signing, then that's not going to be effective. I think that's real important, And that's going to include our provisions that are not required in the statute, but that our law firm thinks are important and worth the writer's cramp. Okay, now I'm going to let Crotty Denicolo take the next 4 minutes. It'll really seem like 5 to talk about the gifting language. And then Ken Crotty's going to come on with a separate PowerPoint due to the miracle of Janine, our IT expert, who none of you are ever allowed to hire. Go ahead, Chris.
Thanks, Alan. One of the things to take from this new power of attorney law is the fact that they almost give you a clean slate here, and that you have to prescribe the specific authorities and powers that principals are to give to agents under a power of attorney document. And as Alan indicated, and there must be due regard given to which powers you want to give to an agent. You want to consider what the principal has done in the past with respect to gifting and estate planning. Here on page 11, if I could scroll back here, we have a special provision regarding gifts, and we specifically provide that gifts can be made in excess of the annual exclusion, federal gift tax annual exclusion of $13,000 per year. And if you don't provide that specifically, the statute limits that. And that's something to consider, because you can just put a broad gifting power in the document, and an agent's going to be limited with respect to what estate planning transfers they can do for their principal. One other provision that we want to make note of here, Alan mentioned creating a separate gifting agent or a gifting committee. If you look here at the highlighted language on page 11, we often put restrictive language so that an agent can't gift to or for their own benefit. If the principal is still alive, we require, or still has competence, we require the consent of the principal. Or if the principal is incapacitated, we often require approval by an independent attorney or a court of competent jurisdiction. It's also a good idea to require the consent of the residual beneficiaries under the agent's estate plan. And that's to prevent any conflict of interest and any disputes arising down the road. With these documents, we don't want to open up possibilities for litigation. We want to try to cover as many bases as possible. Excuse me. Okay, another issue regarding gifting is whether an agent having a gifting power is going to have a general power of appointment for federal tax purposes. Now, this can be taken care of by this language I'm highlighting here. If you limit the agent's gifting power to 5% of the assets or $5,000 in a calendar year, this would cover any duties or any issues that you might have regarding that federal gifting. It's really unsettled under the federal tax law whether this power would be considered to be a general power of appointment under the tax law. But you may want to put this in there, especially if the agent is going to be wealthy or the client is wealthy themselves. Okay, and as Alan's pointed out, we have DNA powers here that I'm highlighting here on page 12. If you look at all these particular issues here, they're designed to address particular circumstances that might come up regarding gifting, such as valuation of property, specific types of property that an agent can gift tax exclusion consents, and all sorts of issues that we can make sure that we cover. As I said earlier, this is like a blank canvas that we want to make sure that we delineate all of the powers that an agent can perform on behalf of a principal, and don't want to leave much open for interpretation to avoid litigation down the road. And as you can see, these powers are pretty straightforward, and they do cover a variety of situations. I'm going to pass this back to Alan for the conclusion.
Chris, thanks. That was very good. Okay, I want to thank all of you who have attended this webinar for getting through the power of attorney part. Now I ask you to please give us any questions, comments, or suggestions that you might have. I'll be glad to send a revised edition of this in compare form.